great pleasure to introduce Jack Russo, Managing Partner of Russo and Hale LLP. He's going to talk to us about intellectual property and so, and Jack has been to the ethical analyst before and he really enjoys interacting with students, so please don't hesitate to ask questions. This is a very rare opportunity for us to learn about the subject. That will be the floor to Jack.
Thank you very much. I guess I would call this a very interactive discussion. I have a couple, maybe a dozen slides, and the intention is to just spur some discussion on a topic that I think is much larger than intellectual property. The way I think of it is, what is the interface between intellectual property, creativity, freedom, and innovation? How are all these things supposed to work together? I've been given an introduction already. I have a few slides about myself. What hasn't been said, I'm also the managing partner of Florence Ventures, which is a very small, sort of garage stage venture capital firm. We literally look at people with ideas in the garage, trying to get out of the garage, trying to actually build something. The story I tell about this is when I first started in law, I had the privilege of seeing the formation of Apple Computer. When Steve Jobs and Steve Wozniak walked in and said, we want to start a company. Of course, this is going back, a few decades at this point, but the partner in the corporate division at the time of the firm, it was just a small firm, said, what's the name of the company? And the response that was given, well, we're thinking a very friendly name. We're thinking Apple. Not even Apple Computer, just Apple. In fact, they've now, decades later, reduced the name from Apple Computer down to Apple. But Steve Jobs originally said, we just want the name Apple. And the corporate partner said, Apple? For a computer company? Are you nuts? You'll never succeed. Of course, the next breath out of Jobs' mouth was, but we want you to take the fees in stock. We don't have any money to pay your fees. Of course, the corporate partner said, well, with a name like Apple, we don't think you'll succeed, so we'll pass on taking stock, which is about the worst decision that was ever made in the history of that firm. And the result, in any event, was they paid the fees, the company got started, was very successful, and they all lived happily ever after. I serve as a federal court mediator, arbitrator, and a judge pro tem, so I see lots of disputes, and I'm going to spend a little bit of time talking about weapons property rights when there are some disputes. So some questions you might want to think about as we cover them is, well, what is this whole topic of intellectual property, which some people just call IP, two initials? What are intellectual property rights, sometimes called IPR? What interests do these rights promote? What interests do these rights demote? That is, what do these rights kind of submerge in terms of other interests out there? Are these rights needed for creativity? And our founding fathers in thinking, hey, we have to have a constitution that allows Congress to create intellectual property rights in the federal system and also state law to do that. Do we need that? Are these rights needed for innovation, which I distinguish from creativity because lots of creativity happens, but oftentimes it remains in the garage. Oftentimes it really just remains in someone's mind, someone's desk, and maybe even in a patent application that never gets any further. It doesn't actually become a device, doesn't become something that you can use. And what happens in real life? So hopefully in the course of, what do we have, about an hour and a half? In an interactive way we can cover all this. So as I said, there's a constitutional basis for intellectual property rights. Indeed, the founding fathers reduced it to literally one sentence, which is, Congress shall have the power. Of course, I'm lifting up a book that has 1,400 pages of intellectual property law. But literally one sentence, the Congress shall have the power to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. Very elegant way of saying we'll have a regime that will provide some incentive to inventors and to authors. Of course, that's now been expanded to literally 1,400 pages in just the California version, and each state in some ways has their own state law version of the regime that they use. But in the federal system, there's certainly over 1,000 pages, not including all the case law that you might look at. Now, at the same time, Congress also said in the First Amendment, Congress shall make no law respecting, and of course, you know, the establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech or press. So what was set up was sort of this dichotomy where Congress would have power to give incentives in the form of patents and copyrights, but Congress was not to do anything to prevent the free exercise of speech. Well, this creates a very interesting tension between the rights that are promoted and what's demoted, and how the balance occurs in real life between the free exercise of speech and really the fair use of patents and writings and what's protected. So I'm going to cover generally in a more detailed way what intellectual property is, as well as what intellectual property rights are composed of. And then hopefully, very quickly, we're going to get to the heart of what will be the thesis of this talk, or the question for this talk, which is, do we need this huge regime of intellectual property law to actually spur creativity? Or would, in fact, creativity happen for other reasons? And my thesis, and this is based more on experience of talking with inventors and authors, is they often don't necessarily think about law as they're doing their inventing and they're doing their authorship. In fact, it's often very much an afterthought. It's not like they go into it thinking, well, the reason I'm doing this is I'm going to get a patent and somehow I'm going to become very successful. Now, there are people like that, and certainly there are some very famous inventors who were lawyers, and I'm sure they thought about the legal side as they were inventing. In fact, the inventor of the original copy machine, which was from Hale Corporation, was a lawyer. And so patenting that machine was very important to him. But putting the lawyers to one side and looking kind of at the rest of humankind, most people that come into a law office, it's sort of an afterthought. This is what happened in the course of my inventing, and I'm going to explain what I think goes on and I'll connect it up with a theory that I think validly connects, although the person who had the theory of a psychologist at the University of Chicago hasn't necessarily attached it to inventorship. He's attached it to other things, and I'll explain that. So intellectual property is really this bundle of rights which arises from intellectual activity. And we're going to probe the question of what causes the intellectual activity in the sciences and industries, in literary and artistic fields. The intellectual property arises from creations of the mind, inventions, ideas, images, expressions, literary and artistic work, symbols, names, you name it. Almost anything can be protected. It includes inventions, writings, industrial designs. Indeed, what Congress has said is anything under the sun made by man is potentially protectable. A very broad statement. Indeed, that statement has been used to justify patenting of software. Intellectual property rights include patents, which can be thought of as novel and non-obvious inventions. And it's kind of interesting when you think about it, because some people think, gosh, it has to be really something hugely big. But if we pause for a second and we jump over to something like Google, you'll see there's patents on things like improvements to a toothbrush. So if this wireless works, you'll see that even back in 1938, but even going forward to the year 2000, there's a number of patents, and now they're readily available on Google, where there are improvements to even a toothbrush, which we all know was invented hundreds of years ago. So people are still creating novel and non-obvious incremental improvements to very commonly known inventions. And this continues. I mean, it continues, obviously, electric toothbrush and all sorts of other devices out there that build one on top of the other. Copyright is somewhat similar, although it's any originality that constitutes expression. So for those of you who are taking notes right now, as you translate what I say into your own notes, you're creating a copyrightable work. From the moment that the ink manifests itself on paper in the form of fixation, you're processing, unless it's an exact copy of what I say. If it's an exact copy of what I say, you're just sort of taking down my expression and you're reducing the copyrightable form what I say. But for example, if you're deciding to take it down in a different language, you're deciding to summarize it a different way or graph it in a different way, that's your copyrighted expression. Trademarks are particular brands or names that are put on goods, and we'll get into a little more depth on each of these. Trade secrets are probably some of the hardest things for people to understand, because it could be almost anything that provides some independent economic value. Think of that as someone would want to license this from you because it would take them time to do it. So for example, compiling lots of research on a particular subject into a book, even publicly available research, like whoever, in fact it was a law firm, that compiled all of these intellectual property laws in one book. Sheldon and Mack did it. And they built this book and they kind of organized it and indexed it. And I'm sure it took them hundreds of hours to do, even though the law is more or less available, readily available, indeed online. But they organized it in their own way. And if they wanted to keep this book as their secret, based on the organization they used, it had value, it has value, and people would potentially seek to buy it from them. Now there'd be a question of how robust was that secret, because the contents is all public, and we tend to think of secrets in a more secretive way. In fact, in the newspaper this morning, one of the things I do before I give a talk is I typically look at newspapers and try to figure out what's going on that's sort of generally pertinent today. And today, I think it was in the USA Today, there's actually a trade secret trial going on where a secretary took home with her the formula for Coca-Cola, which is like a very valuable trade secret. And apparently she's charged with conspiracy with others to sell that formula to Pepsi-Cola. Now you may take a pause and say, wait a minute, Pepsi is an ethical company. Would they really buy the formula for Coca-Cola? Now that's an interesting question, and they'll probably get to the bottom of it during this trial. But the trade secret formula of Coca-Cola, which has been a secret for over 100 years, and supposedly is at the heart of that entire business. In fact, someone once said, I recall in business school, someone once said, if every factory of Coca-Cola burnt to the ground and there were no further employees, but they still had the formula for Coke and they still had the trademark brand, they could get capital to restart all of that overnight, and they rebuild that business overnight with no fixed assets. They restart just based on the formula and the fact that they have the brand. And that's the value, that's the ultimate value of intellectual property. If an entire millions, if not billions of dollars of plant and equipment can basically burn to the ground, then, and the intellectual property that's there can restart the business overnight with venture capital or equity capital that's put into it, you have to say to yourself, that's pretty valuable intellectual property. And that's the nature of a trade secret. Other IP rights are, for example, contracts, publicity rights, rights of association, things that generate some valuable goodwill, something that people will bargain for in an exchange in some form. And the categories seem to be expanding. Indeed, it seems over time, if anything, the categories have expanded. So if we look at patents in a little more detail and what happens in the US Patent Office, the very first thing that one, say, sitting down, imagining an invention, whoever imagined it, I don't think it was Apple who imagined the MP3 player. I think there was a company years before Apple that came to the conclusion that moving music to digital form and putting it on some remote player would be a great idea. And whoever the inventor was for that, when he came up with that conception, he had in mind that the world was moving in a direction just as it had, if you look at the history of it, from vinyl to 8-track tape. I don't know if any of you remember that. There were actually 8-track cartridges, to cassettes, to CDs. There was sort of a logical progression where it seemed as though the item was getting smaller and smaller, packing much more music to it, and indeed was going to a form where the CD was being read into a memory. And the next logical step is just provide the memory and let the memory itself be the next step. And that conception turned out to be novel and not obvious, even though looking in hindsight, one would say, yeah, that kind of makes sense. Over time, things are getting smaller, more portable, can pack more. But what that person did, I don't know who it was, used diligence to reduce that idea, that novel and non-obvious idea, to practice, which is some prototype, some drawing, something that takes it out of the person's mind and expresses it in a way that a third party hopefully can verify, because dates become important in the patent regime. And then there's a filing, and it has to be timely, which the place lots of people get into trouble with inventions is they start talking and marketing the invention to others, and they let 1 year pass from the date they first start marketing the idea, and a 1-year bar gets established by fact of marketing of the invention before making the filing. So these days, and this is a recent development in the Patent Office, you can file your own provisional patent application. You can literally file it yourself. You don't necessarily need a lawyer to write claims for you. So lots of people write up descriptions of their invention, and for a relatively small fee, I think it's under $150, they file their own provisional patent application. And then they can wait up to a year to file a complete patent application with claims. They sort of test the idea for a year without losing these rights. The prosecution of the patent happens after claims are filed, where an assertion is made of what the monopoly is, what the scope of the monopoly is that's being sought. And then enforcement typically happens either through licensing, for example, whoever developed that MP3 player going to Apple and saying, I have a patent application, I believe it's going to become a patent, you have an inventory of computer systems that could potentially connect up with my system, I see the future of music as online, do you agree? And then working out some deal. And then the duration of a patent can be up to 20 years. So it's actually a fairly long process often for inventions that don't necessarily last that long in real life in terms of the way innovation turns. Now I want to show you what's happened over time. I pulled some data, and it's kind of interesting. The US Patent Office publishes, they do it in sort of statistical form. So this is about 42 years worth of data from 1963 to 2005 of what was happening in terms of filing of different types of patent applications, the year of the filing, and what was granted. So I did some very simple spreadsheets to give you the flavor of what happened. I took the data into a spreadsheet, and then what I did is I just did sort of some very simple charts to give you the flavor of what's going on. So generally you can see for about the first 20 years, so the years are on the bottom, year one being 1963, but literally the number of patent applications, total patent applications, hovered between 50,000 and 100,000 until about 25 years out, basically about 1988 or so. All of a sudden you can see the world is now recognizing patents and patent applications, because these are just patent applications, and we get a doubling, we get a tripling, I mean literally almost a quadrupling, over 200,000 applications per year are going into the same patent office. I mean the patent office expanded, obviously, it grew, it added examiners, but what happened in the world? Something happened in the world that people started to take seriously filing of applications. Now I think it's not shown here in this data, but I think what's going on, many more individual inventors started to file their own provisional patent applications without lawyers. Basically taking the view, I want to make sure I have something on file during that 1 year period so I'm not subject to a bar. So I took the same data and just put it in a different form so you can see what happens with the chart over time. And then what I did is I looked at how the grants went, and this is kind of interesting. I looked at what was happening over time in terms of the percentage of applications that were being granted, and the general trend, about half. If you look at in some years, it seems like it's higher, goes up to 70%, but over time, it actually looks like the line is fewer patents are being granted from those applications, which would also be explainable that the do-it-yourselfers are not necessarily competent in getting the patent through the patent system, and a lot of patents are being abandoned. So it's sort of like someone comes up with an idea, they file the provisional application, they let it sit there for about a year, see if they can do anything with it commercially. If they can't, they basically let it lapse. Now what happens today, based on the modification of the patent law, is the application itself gets published after 18 months. So the effect of that is much more information, even though there's an incentive to patent, you might say, well, there's a risk of a monopoly. Lots of patents are lapsing and creating a larger volume of public domain, published public domain information. So the result in some ways is good because the world is getting more public domain information over time. But you can see in general, the numbers are high and still the grants are high. So that's generally what's going on in the patent office. I don't know if folks have questions about patents, because I want to move to copyrights and then really get to the copyrights and trade secrets and then get to the rest of what has to be said. Now, when you get a lawyer involved with the patent application, you can end up spending a lot of money, sometimes in excess of $25,000 for a particular application. So it's not cheap. And indeed, these provisional applications are a way to save that money until you're sure you can actually do something commercially. Copyright Office and copyrights are actually far different. Copyrights are much easier to create because they're automatically created from when the work is fixed in a tangible form. The recording of this presentation is such a fixation that creates a copyright in this work. The more interesting question is, as you start interacting with me, who owns the copyright? Because it's almost like multiple people and multiple authors are involved with this. The registration just adds protections. That is, over time, filing the registration application gives you additional rights. For example, attorney's fees, injunctive relief, statutory damages. The copyright notice also prevents offenses, such as someone saying, I didn't see a copyright notice, so I thought it was in the public domain. Therefore, I used the material. That gives rise to a defense called the innocent infringer defense. But copyrights extend for a long time, often over 100 years. The duration is the life of the author plus 50 years. So if you create something at the age of, maybe the average age in this class is, 25. If you create something at the age of 25 and you live to the ripe age of 95, the copyright exists for your life, that's 70 years, plus another 50 years. So it's like 120 years. That's a very long intellectual property. So great works, I suppose, and you can think of some great works that occur, like, for example, I suppose Disney has created some really interesting great works and is now deceased, and they would otherwise fall into the public domain. But over time, they have tried to protect those copyrights, and they've tried to sort of batch around them other intellectual property rights like trademarks to try to get more protection. But it's a long period. But the registration is relatively cheap. It's like $20 filing fee and filling out a form. There's no real examination. It's not like a patent. There isn't someone really looking at prior art. No one tests, did you copy this or was it original? Your attestation, your declaration under oath that it's original is sufficient. Copyrights are also protected by criminal statutes against, for example, willful counterfeiting. The patent area has nothing like it. Patents are presumed valid, but in some ways the law recognizes that people may challenge patents. So there's no criminal regime. You can't be held criminally liable for violating a patent. Now, you may be held liable in damages and there may be injunctive relief, but there isn't anyone from the U.S. Attorney's Office that's going to say what you're doing is a criminal violation. So turning to trademarks, non-generic, non-descriptive names, what are sometimes called arbitrary or suggestive trademarks, are what give rise to trademark rights. And indeed, it takes some degree of commercial activity to really get a trademark right. So in the news, kind of an interesting story, again, this was the USA Today. I don't know if any of you read or watch any of these CNBC financial programs, but there's a woman who's apparently famous. I've heard of her, but I haven't watched the show recently. Maria Bartiromo, or anyone knows, she's like a very famous woman in the stock area. Well, she's decided to register, her nickname on the show is Money Honey, because apparently she's been successful in making investments, and she's registering that name for the purpose of protecting her plan for launch of clothes, toys, piggy banks, and other products. So it's kind of an example that someone who generates some following on TV can capitalize on that in generating licensing deals for the goodwill that they generate, even though you might say, well, isn't CNBC trying to bear hug that goodwill? If they can kind of establish their own name or their own trademark or their own signature, they can generate their own intellectual property right around that. That's what she's doing. Of course, the strength of the mark, that may not be the strongest mark, because a completely arbitrary mark like Apple for computers, which was very arbitrary and threw that senior partner off in that first meeting, like, you know, I remember him saying, well, don't you want a name with an X or a Z like Xerox? Because Xerox was very popular back then in the 70s. And they looked at him like, are you kidding me? We want to be anything other than that. Well, don't you want like 3 letters like IBM? Maybe we should call it, you know, A, Apple, C, Computer, Inc. How about ACI? And they're all looking at him like, you know, he's from the moon. Trademarks have the potential for perpetual life. In general, the registration cost is relatively cheap. You know, typically under $500, even with the lawyer involved with it.
What's the trademark in a registered mark?
Yeah, let me explain that. When you pick a name, like Maria Bartiromo may have decided to ship some piggy banks that say Money Honey. When she decides to put that on her product, she can put a little TM next to it as a way to say, I'm declaring that this is going to be my trademark, but she doesn't have a registration yet. The registration process typically takes in the trademark office about a year. I should say something about this. The registration process for a trademark typically takes about a year because it's a publication cycle. When you file the trademark application, the world gets a publication in a book that comes out monthly. It's typically even bigger than this book. It's called the Official Gazette, that gives notice to other trademark owners that you're declaring this is going to be your trademark for a particular line of goods. Well, if there's someone who has Money Honey on some other product, let's say honey or some food stuff, they might actually object to what she wants to do and say, we were planning to move in the toy area ourselves, and we think we were there first, and we think you're capturing some of our goodwill. So those fights are typically resolved in the trademark office by a trademark examiner. In the copyright office, the process takes much less than a year. Typically, you get a copyright registered within 6 months. I mean, there is some delay based on the number of copyrights that are being filed. Patents typically take 2 to 3, sometimes 4 years. So it's a long cycle because there's much more examination of art there. Trade secrets are the last area that I'll cover and then we'll get into the meat of this. This is by way of overview. It's a state law protection, although there is some federal law that protects trade secrets as well, but mainly it's state law. There's no registration, which means there's no examination. Indeed, what happens is the validity of the trade secret is self-determined. By that I mean, you have to make a judgment call if you're going to declare something to be a secret and decide whether you want to use the regime of non-disclosure agreements, contracts, confidentiality agreements, educational devices for your employees. For example, in that case I described that's going on right now where the secretary walked out with the Coke formula, I'm sure lots of the defense must be Coca-Cola didn't really educate her that she shouldn't walk out the door with the formula for Coca-Cola. In fact, that probably should be locked up. And according to the newspaper, her testimony was, well, my boss told me that I really had to get more familiar with the business, so I took this whole stack of files with me home to get more familiar with the business. And you know, maybe that's going to work. I mean, it's going to be interesting to actually look at the transcripts of that case and what the decision is, because what may be at stake is whether the Coke formula has itself fallen into the public domain. I don't know that Coca-Cola stock is being impacted by this, but in theory, if the judgment of this court is Coke formula is now in the public domain, and anyone can get into the business of coming out with Coca-Cola. Obviously, they can't use the brand name Coca-Cola, but they can say, you know, tastes just like ... and let everyone know by citing the particular case that's the law that, hey, we just decided to take advantage of this outcome. So Coke may have a problem there, depending on what happens. They may have to be doing a lot of explaining at this point about what have they done to protect the non-publication and the non-disclosure, which they have historically over time. But what have they done recently? What types of confidentiality agreements have they used? What other protective steps have they used to avoid disclosure? So there are civil and potentially criminal penalties there, but by and large, it's pretty much almost like an ethical standard between companies in terms of protecting their secrets. But the flip side is, lots of companies have divisions of competitive intelligence analysts who are looking at what's going on, you know, what's being published, what's being filed, what trademarks are being filed, what provisional patent applications are being filed, what's going on. So now I want to turn to the question for the day, which I think is at the heart of this series of lectures, which is is this gigantic body of intellectual property law, and there's a lot of it. I mean, literally, this is just scratching the surface. These 1,400 pages, this scratched the surface of the body of law that's out there. Is it a threat to creativity? Is it a threat to innovation? You know, what if we didn't have all this law? What would actually happen? And there's a professor at Harvard, or maybe now he's at Stanford, Larry Lessig. Is Lessig here now? Is he here? Well, Lessig makes these 4 points, and I'm going to repeat them, but what I'm about to say is his stuff, so let me give him attribution. He says it in a slightly different way, so our expression is slightly different. But he says creativity and innovation, and his argument is always builds on the past. I would drop a footnote here and say, and I didn't put the word always in because I actually think when there's a major invention, it almost doesn't build on the past. It's kind of the structure of scientific revolution, as Kuhn would say, kind of ignores the past, disrupts the past, says we want nothing to do with the past. We want to do something completely, it's almost like a completely different view takes hold. So I don't buy the view it always builds on the past, but generally I think he's right. Incremental creativity, incremental innovation builds on the past. The past, and this is the second statement, these 4 statements go together and they create kind of a logic that's going to be the heart of what we need to talk about here. The logic of what are we doing as we create more and more law in this area of intellectual property rights. The past seeks to control the creativity and innovation which seeks to build on it. In fact, he says the past always seeks to control the creativity and innovation which always seeks to build on it. That's the way he puts it. I don't buy that, but you get the gist of it. And in some ways, there are counterexamples because obviously we have open source now, and that represents the past, allowing people to build on open source so long as they follow the rules for open source, where you say, we're not restricting what you do, we're only sort of adding to what you do. But this is the second point he makes. And then the third point he makes, and I think in the last time he gave this speech, he said it was going to be the last time he used these points, so maybe it's right that I pick up and question it. Free societies enable the future by limiting the effect of the past. I mean, in general, if you think about that proposition, it's true that if you want to have a free society, I think he says free societies should always enable the future by always limiting the effect of the past. And that's what I'm questioning, sort of whether the word always really works. Free societies enable the future by limiting the effect of the past. And then the question, he asserts, of course, our society is becoming less and less free, but I'm going to put it in question for him. Is our society becoming less and less free as more and more IP rights proliferate? And by IP I mean intellectual property rights, everything we just talked about. As more and more of this stuff proliferates and we have more and more law, more and more lawyers, more and more cases, more and more litigation, are we sort of losing some freedom? And I think this is sort of at the heart of what this group of talks is really about. So I'm going to question it, and I'm going to question it by sort of taking a tangent here. And the tangent goes to Mihaly Csikszentmihalyi, long name, I can get you the spelling, at the University of Chicago, although now I think he's in Southern California, but he was at the University of Chicago for years. He's a psychologist. He was actually originally a newspaper reporter that went back to school and became a PhD in psychology and studied this concept of flow. Now, I don't know if any of you know about this concept. If any of you have experienced the sense of loss of time as something is occurring, it could be art, it could be dance, it could be swimming, it could be writing, it could be computer programming, it could be inventing. But this sensation of, you know, when I was a computer programmer before I went into law, I remember once sitting down, and back then we used to punch cards, but before we punched cards, we would write the code. We'd write out the code, whether it's assembly language, PL1, Fortran. And I remember sitting down, and I remember it was about like 2 in the afternoon when I got started. And I remember getting up just to go to the bathroom at like 3 in the morning. I had completely lost the sense of time for like 12 or 13 hours. And it was just the physical sensation of, you have to go to the bathroom. Everything else had kind of taken over. And I remember a very elegant computer program that I had written. I'm sure it's in some storage box somewhere because saved everything, including the punch cards with the original printout wrapped around it with the rubber bands. And I remember just thinking to myself, what happened? And I don't know, in the audience, we could do a show of hands. Have you had that sense? I mean, I'm going to describe that sense. That sense of complete encapsulation. Now, my thesis is this. My thesis is, so long as human beings have the ability to reach that flow state, they will continue to innovate and create regardless of whether there is law, isn't law, whatever. There's something in the human instinct that drives to this flow state. And I'm going to describe it so each of you, maybe beyond the one person who said, yes, that happens. Well, if I have others say, yeah, I strive for that, because there are people who actually think there's almost a spiritual connection that occurs. Like they talk about, how is it that Mozart created this music? How could he do it? How was he able to do it? He must have had like this connection to the gods. He had this spiritual connection that transformed them and made him into an instrument of some higher power. It almost becomes that magical for people. And it's not limited to any domain. It's not limited to inventing. It's not limited to writing. What was the context that you lost the sense of self or a sense of your awareness? What was that context?
Oh, it was in a water polo game, actually.
Right, it could be a physical activity. It often can be. You just lose every sense of time and the adrenaline is flowing. In fact, basketball players talk about getting hot, where you just can't miss a shot. Like, just give me the ball because things are so percolating. So the way Mihaly, Csikszentmihalyi, I'll just call him Mihaly or Mike for short, Mike puts it is, how much attention do we actually have available? And he's studied this. He has research techniques for studying the bits of information that seem to stream in so quickly. He talks about it as over 100 or 114 bits. I don't know how you could be that perfect in terms of bits because it seems hard to count. But he talks about over 500,000 bits of information per day, growing, particularly now with Google and the ability to pull up lots of information very quickly, to over 1 million bits of information a day in your waking life. And on average, I don't know what that number is, probably well over 168 trillion bits of information hitting you in an average lifetime, with the volume and the velocity growing over time. Now, you guys must feel that way. Some of you are in graduate school, some of you may be in undergrad. What's the show of hands? Who's in graduate school? Most in graduate school. So, basically, lots of information, lots of writing, lots of reading. And what's the effect of this over time? So he talks about 150,000 bits per day go to work or study. Some of you who are more diligent can up that to 200,000 or 250,000. Some of you who aren't. 200,000 go to what he calls maintenance. For some women that might be higher, like 250,000, dressing, eating, cleaning, traveling, dealing with your high heels breaking, whatever, And then 150,000 bits of information are free time. And it's the free time, actually, that I want to explore here, because I think what happens for lots of people is they use their free time in particular ways that ends up creating something. And then they're actually surprised at what they've created. It's not like they're thinking, gosh, I'm going to get a patent, so let me sit down and invent something. They just get into a flow state where they do something or invent something or write something, and then they realize it's much bigger, potentially, than what they thought. So he talks, and these are some of his quotes from his 1975 book, In Composing Music. He talks about it as you are in an ecstatic state to such a point that you feel as though you almost don't exist. I have experienced this time and again. My hand seems devoid of myself, and I have nothing to do with what is happening. I just sit there watching it in a state of awe and wonderment, and the music just flows out of itself. This is someone who he interviewed who talked about this state of being. And in poetry, it's like opening a door that's floating in the middle of nowhere, and all you have to do is go and turn the handle and open it and let yourself sink into it. You can't particularly force yourself through it. You just have to float. If there's any gravitational pull, it's from the outside world trying to keep you back from the door. The sensation of just leaving ordinary life. And I think, to your point about sports, I think it happens a lot in sports. In figure skating, there was another researcher, one of his postdocs, who researched this actual category of figure skating, what happens in flow. It was one of those programs that just clicked. Everything went right. Everything felt good. It's like a rush. You feel it go on and on and on, like you don't want it to stop. It's going so well. If any of you have seen some of the Olympic performances where some of these athletes, particularly the couples, are really on and you say, what's going on? They've transcended the art. I think that's the description going on. You hear the music, but you're not aware that you're hearing it because it's all part of it. It's like you've lost yourself. So what he has broken this down. Yes, sir?
I just want to comment on this real quick. And
Go ahead.
put it in the perspective of innovation and creativity. Many people have sort of documented similar experiences taking drugs, especially LSD.
Yes.
And I think it's really interesting that the Bay Area was where probably the most amount of people were taking LSD in the 60s, and now it's Silicon Valley that's considered the innovation hub of the world.
But you know, there's actually a book that's on that point, oddly enough. John Markoff of the New York Times, and he was recently here promoting the book. He recently wrote a book where he looked at the history of Silicon Valley, and he actually makes an argument, like the one you're suggesting, with some documentation that maybe we sort of genetically changed the valley to some degree. I mean, this is sort of the point, that people felt this sensation, I'll just say artificially, because I think what Csikszentmihalyi is talking about is a self-induced, non-drug-based ability to move yourself, and I'm going to describe in a minute how to get there. And the reason I'm connecting up to innovation and creativity is, my thesis is, you wouldn't need all these laws necessarily. It's not like the world would stop when you have all these laws. Now you might say, well, wait, you're a lawyer. You should be arguing about more law, not less law, but I'm going to tell you something. Most of the folks I know, and most lawyers I know, and certainly most judges I know, believe there's way too much law. They actually would love a civil society that had like very few laws. They look back at the founding fathers writing that one sentence and saying, that's so elegant. You know, can't we just have like people respect the fact that an invention was created and just, you know, not copy it out of, you know, reasonableness and kindness and reciprocity, and not out of some view, well, you know, I might get enjoined and there's attorney's fees possible and civil penalties and punitive damages and a jury and an appeal. And I mean, you know, it's a whole different way of thinking. But there is a book, and I can find, if you leave me your email address, I can find the title. Let me do these 7 steps very quickly, because I think more of you will see that you probably have been in this flow state. Indeed, I think some people who are writing the dissertation should imagine getting into this flow state as a way to have a better dissertation. Completely involved in what we are doing, focused, concentrated. A sense of ecstasy, of being outside everyday reality. I think artists get this, I think writers get this, I think researchers do too. Great inner clarity, knowing what needs to be done, and how well we are doing it. Kind of a feedback loop that says, this is all correct, this is all elegant, this is all just clicking. Knowing that the activity is doable, that our skills are adequate to the task, and I'm going to make a point about that in a minute. A sense of serenity, no worries about oneself, a feeling of growing beyond the boundaries of the ego, this sort of almost spiritual-like connection that the whole physical side of it's irrelevant. Timelessness, thoroughly focused on the present. Hours seem to pass in minutes. That 13-hour stint, which I never was able to recreate again, which is probably why I'm not a computer programmer, because I think programmers that can routinely recreate that sense of elegance in their programs stay with that art. I mean, I think that's part of what drives them. Intrinsic motivation, whatever produces the flow state, becomes its own reward. Those are the 7 statements he makes in description, and then graphically, the way he talks about it is, and this goes to this question of motivation, skills in the horizontal axis, challenges in the vertical axis. Think about it as, if there's a right match between skill and challenge, like you're on fire, things are clicking, you're driving additional skill development through the challenge. So if you're a downhill skier and you started on the green slopes and you move to the blue slopes and you move to the black slopes and now you're on the double black diamond, you're a little over your head, you're a little worried, But all of a sudden, things are starting to click, and you're going really way faster than you've ever gone before, but your skill level has caught up to your challenge. That moment when you've taken a leap of additional skill development. I know probably most of you are like snowboarders saying, what are you talking about, Steve? Get lost. But the way he looks at it graphically, he says, when you have a lot of skill and you have less challenge, it's control. So a good example is driving a car, or driving a car fast. Indeed, driving a car really fast, you probably would get into the flow state and you get somewhat out of control. A lot of skill with a lot less challenge is relaxation. Sort of like sitting back. I mean, I think a lot of people do this watching movies and TV, even if it's a documentary or something that requires a little thought. Very little skill, or less skill, and less challenge is boredom. Indeed, in those moments, when you start feeling boredom, you have to ask yourself, how do I amp up the challenge here? Something is wrong. The reason I'm bored is this is not challenging me, this is not developing further skill. Very, very low skill and very low challenge is apathy. These are typically people who say, you know, I don't give a damn, this is irrelevant, I'm out of here. More challenge with less skill is worry. I mean, we can all think about that, particularly as our bank balances may not be exactly balancing and we're thinking, gosh, this is going to be a challenging month, where am I going to get the money to make the payment on my credit card? And indeed, as it becomes more and more challenge with not enough skill, there's anxiety. And then the state you should be in when you start a class, I think, particularly if the class is challenging, is arousal, which is a lot more challenge and your skill level is not yet up for it. You're being pushed to get your skill level up for it. So graphically, again, the way he looks at it is you're pushing the boundaries to move into flow. You're going to move up into anxiety, and that's going to push your skill level to move you from A to B to C to D to E on this graph. And all of life can be viewed to some degree as this constant evolution where you're building skill over time with more and more challenge. Now, I introduce all that to you as a way to try to promote a view that says, I don't think this law, or all these laws, are at the heart of getting people to do what the flow activity or their favorite activity, hobby, work, love life, whatever it is that's generating flow, inventing. I don't think the law is what's doing it. I think there's an inner human motivation that will always be present, regardless of the law. So then we're going to get to the question of, and these are just examples of all these different states. Driving, work is control, eating, reading is relaxation, work and household chores can be boredom, apathy, loneliness, TV, family problems, hassles, work stress, new tasks and learning, and arousal, all the things you would expect. So what I want to get to is the what ifs, which really should drive the discussion. So what if we decide to have no patents in the US? We just decide to say, the founding fathers said we can have patents. They didn't say we had to have patents. They said Congress shall have the power, not the duty, Congress shall have the power to promote science through patents, right? So again, recent newspaper article, this one in the New York, in the Wall Street Journal this morning, Thailand moves to trim drug costs by eliminating all patent protection for drugs in Thailand. In the Wall Street Journal this morning, page A8, basically taking the view that US, mostly US based, but some European drugs, because this regime, as I said, is not only USA, but worldwide, the Thai government unilaterally said, in Thailand, we're not going to have any more patent protection for drugs. And we're going to take imports, mainly from India, where there are copycat drugs. We're going to take those imports, bring them to Thailand, and give them, and the way the story reads is, they've gotten the price down for various drugs, including HIV drugs, to a price of under 3,000 Thai, I guess the currency is called the baht, B-A-H-T, right? Down to like under $90, where before it was like 10 times that. And they just unilaterally did that. So governments can choose to do it. It's not impossible. It's not unheard of. Now, there's a backlash and there's an industry committee that's being formed and say, well, what do we do about this? Because if Thailand does it, then what happens when Cambodia does it? And then what happens when Vietnam is, you know, sort of like the domino theory, sort of what we went through the Vietnam War on, is similarly could happen in the patent area, at least so far as drugs are concerned. Now, the thought that occurred to me, and it was kind of interesting because it came up in a seminar I went to last weekend, which is, the topic was the gaming of pharmaceutical patents. And it was an economist who studied, I mean, this just happens to be something that's, you know, synergetic with this point, is there was a law called there is a law called the Hatch-Waxman Act. That act was designed to allow the US economy to promote copycat generics so long as the generic could validly reverse engineer or get around a patent. For example, when a patent is written, it's often not so inclusive that it prevents another drug that has similar features from studying the patent and designing around the patent claims. A really good patent drafts person will hopefully avoid that, but oftentimes the prior art doesn't allow the entire monopoly to be taken, so there's sort of a looseness in the door that allows a copycat. So Hatch-Waxman motivated the copycat companies to try to find those design around. So it's a little bit like, we allowed you to create the monopoly, now we're going to allow you to figure out a way to get around the monopoly, and we're going to incentivize you to do it by granting the very first generic an additional exclusive right, an additional statutory exclusive right under the FDA regulations. So think of it as a quasi-patent. When I talk about other IP rights, not patents, well, this is a statute that's trying to generate some generic competition. Now, what this economist said is what happens in real life is the major patent owner negotiates with the generic to keep them off the market. And so an unanticipated consequence was it's actually now taken longer for a generic to get on the market after Hatch-Waxman, like 30% longer. It's gone from an average period of 9 years to like 12 years as a result of giving the additional incentive to the generic gave them a valuable right to actually trade with the patent owner. So a classic, and he actually studied a particular case where a very large patent holding drug company sued for patent infringement, then negotiated a deal where they were paying the generic $40 million to stay off the market in the event that they lost, even if they lost the patent case, and $60 million if they win, sort of a bonus of $20 million if your lawyers do well. And the net result was it extended the period. So it's sort of like Hatch-Waxman has backfired, and really the point the economist was making is there's always going to be some gaming around whatever intellectual property right, whatever incentive, whatever disincentive. You have to actually, if you're Congress, you have to take a step back and think, well, how are the companies and all their lawyers going to game the system in some fashion to maybe generate an oddball result as a result of this? So I said, what if there are no patents? Now my thesis would be, if there are no patents, people will jump on top of copyrights, trademarks, trade secrets, whatever else they could do. For example, if, I guess someone told me recently, I don't know why they were telling me this, that Viagra patent is going to expire soon. Well, I don't know if you noticed, but there's a lot of advertising going on for Viagra. And a lot of that advertising points out that it's a little blue tablet. I only know this as a result of a very funny story associated with my mom telling me about my dad having these blue tablets. But it's a blue tablet with a certain look to it. So what they're doing is they're getting ready for the patent to expire, and they're trying to generate a larger trademark right around the configuration and hoping that the consuming public asks for, well, I want the blue tablet because that's what I read about. That's what I read about. It doesn't matter. It doesn't matter. Maybe more sophisticated people will go with the generic. So then you have to say, so what if there's no trade secrets? Because I think if my thesis is correct, that if you get rid of patents, people will go to trade secrets, trademarks, copyrights. You'd have to get rid of the trade secrets laws as well. Because I think you all maybe last year covered this topic and said, maybe we can have an opt-in on patent law and get rid of patent law as a sort of mandatory, you may crush a new development. We'll have an opt-in. But the truth is, if you have an opt-in approach, for people who want to clobber another company, they'll look at an alternative intellectual property right as a way to try to clobber a competitor. So this opt-in may or may not work depending on what the gaming is of what plays out with the other intellectual property rights. I don't know if I'm making myself clear. You have to imagine these intellectual property rights like a gigantic ocean of potential rights, or maybe some people would say it's kind of like you know, having you know, some obstacles in the ocean. You know, having some what did the Titanic crash into?
Iceberg.
An iceberg. Having like icebergs in the ocean, and having lots of icebergs in the ocean. And the way to think about it is you get rid of one iceberg, and a bigger one gets created because everyone starts moving to a different intellectual property right. Do you have a question?
Yeah, I just wanted to clarify, because this class hasn't heard the opt-in argument.
Okay, you want to give it?
Yeah, last year we discussed this topic, and the idea was that you shouldn't have to just wake up and find out that you made a patent violation by your own creativity. So the patent regime is voluntary, and you can sign up, and in return you can get access to a lot of the existing patents. But if you choose to stay out of it, then you don't get the benefit of the knowledge, but you also can't be prosecuted for ideas that you come up with.
But keep in mind, the knowledge is generally published. The concept of a patent is it's a publication system which is sort of generating an eventual public domain deposit, albeit over a couple of decades, right? Now what you're describing, just to let you know, it exists in real life. It's called a patent pool. So for example, in some areas, like Wi-Fi, there's lots of technology being developed and lots of overlapping incremental improvement patents for Wi-Fi, or for any of these standards. There's lots of standards. Dolby has standards that are being incrementally increased by others. Well, everyone wants to share the knowledge in that pool without getting sued. So the oligopolies that exist in an industry get together, and this is legal under the antitrust laws. They can do it so long as it follows a very strict set of rules that say this is designed to improve a standard. And so long as everyone participating in the standard drops their intellectual property into the pool and cross-licenses it, they can all take advantage of it. So that opt-in exists in this very sophisticated form. There's like a total of 100 lawyers worldwide that just do these pools, and they fly around from one country to another, and you know, they have these very expensive dinners. I had the privilege of watching this once, of how it plays out. It's like a group that are deciding on standards and then more or less drawing in what I call the oligopoly, is the group of companies that will practice in an area that is a standard, whether it's a DVD or a certain type of sound, or MP4, I guess is another standard. All these standards, they deposit their incremental patents in, and then they have a monetary exchange because they have a neutral evaluator evaluate the value of the deposited patent, because they have to sort of try to balance the books, as it were. So for example, if someone deposits a patent, you know, let's say call it a Thailand patent, probably wouldn't have very much value, but they get to participate, and they'd have to put some royalty money into the deal, because they're not giving a great patent, like it's not like a great patent regime is in Thailand, for example. But someone putting a big US patent that has a lot of value, they would draw money out. And so there's actually a neutral committee that's deciding that cross-licensing mechanism. So in theory, the idea that's being promoted would have to be, some thought should be given to how it might be built on this patent pool argument. This argument that maybe patent pools are good. There's a counter argument saying patent pools actually exclude lots of smaller competitors who don't really have the money to develop the patents that they need to deposit into the pool. So it kind of keeps an oligopoly very strong. Yes?
But they could create their own, small business owners patent pool, much like the open source community, which was excluded from the...
Right, the problem is a lot of the major patents that you need to practice in an area, i.e. to avoid the current system where you get clobbered, are owned by larger companies. In fact, a footnote on this, and I want to put it on the tape because it's a research interest I had. I actually started thinking about this talk and couldn't quite get to the point of figuring out what the idea is, but I know there's a kernel of an idea to this, which is if you look historically over what are called long-lived companies, most corporations don't live that long. In other words, I don't know if any of you have picked up, there's a certain beer, I forget the brand of it, that's been around for like 600 years. I forget the name of it, I think it's an Irish brand. It's a family-owned company. It's kind of like Toyota Motor Company. It's been around for a long time because now the great-great-grandson may become soon the CEO. Well, there's a guy at Columbia that has studied long-lived corporations. There aren't that many of them. Like worldwide, there's under 1,000 corporations that have existed for more than a few hundred years. It's like companies dissolve, they merge, they change. You know, maybe Microsoft may be a long-lived corporation, maybe not. Maybe, in fact, you know, their monopoly is going to kill them. You know, maybe the fact that Gates is retiring from Microsoft and it's not going to be a family legacy is going to kill that company. No one knows. But the point is, if you look historically, corporations don't last, even though they're intended to be perpetual. So a kernel of an idea that I had is maybe the intellectual property regime is actually shortening the life of corporations. It's like I have a counter idea that I think is worth some research too, which is maybe people that get into this flow state and are inventive and creative live longer. Like literally their chronological life is longer because they have this purpose. Like someone who, you know, there was a story on the news the other day of some guy that absolutely believed that he could invent, a physicist with a PhD in physics, absolutely could invent a time travel machine because he wanted to go back to visit his dad. And I'm thinking, you know, maybe that guy's going to live to like 115. I guess some woman died today that is the oldest woman on earth, or yesterday is 114. You know, maybe by having this flow state and being driven by an idea, your purpose in life gets remanifested daily as you wake up to attack the idea. You know, it's this notion. So I've been wondering about those two ideas, which is what if we had no copyrights, no trademarks? Would we actually have longer life companies based on other principles like quality? Like companies that really remain in business because they're quality. And one might say, wait, they're going to need some trademarks because their brand is going to be important, their name's going to be important. We've got to have some regime to protect at least quality. Like what is that minimum set of rights that we'd have to have?
Jack, back to trade, I just want to understand what you're saying here.
Sure.
No trade secrets means no protection of trade
Yes.
secrets under the law.
Under law.
I mean, Coca-Cola could still have two guys who know it and they don't talk to anyone.
Well, that's the point, which is if you have no intellectual property law, do people just become very secretive because they say, I can't really share it with you because there's no law to protect me. Now, there's a counter view that says so long, and this was sort of the last point on this slide, which is no contract rights? Gulp? Because there's a theory you can have that says get rid of all of it, and you know what you're left with? Contract rights. You have an idea, it's secret, it's your innovation, you feel really powerful about it. You say to someone, you want to know about this? I think it's really hot. That's a great idea. You have to sign a contract. And there may be no body of statutory trade secret law, no body of copyright law, no patent law, but essentially people will start entering contracts. And you'll get almost this opt-in approach that you're talking about under contracts, where you'd say, well, those people are sharing knowledge based on the deal they have. We can't get access. Now, the problem with that is many innovations, many trade secrets publish themselves by dint of being distributed. They're reverse engineerable.
Like the safety pin.
Yeah, you can
Once
take
you
it
see
apart. It's like this little MP3 player. You know, it's like what Apple, you know, hope they don't sue me for defaming them. I don't represent them anymore, but Apple took apart a historically created MP3 player. It's clear to me. I mean, I think the original MP3 player was by a company called Rio. It's now in bankruptcy. It's very clear to me. I still have the original Rio device, the 16, you know, this tiny 16K memory device. I think it fit like 3 songs. That was the problem with it. It was too small. But even then, it was a couple $100 because it was the new thing. Someone at Apple, and probably someone at a company that Apple acquired, took that device apart and said, how do we put this on steroids? How do we make it so it's 30 songs or 300 songs? How do we make it so it connects up with a music system? How do we make it so you don't have to kill yourself by ripping all these songs? How do we make it so there's a transaction system? They asked all those ideas. So once you release the product, the problem is the secret is gone. And that's where patent law is supposed to take over. That's the theory of the intellectual property. Patent, copyright, trademark law take over. So my thesis on this is you can imagine a world that's much freer, but there's probably going to be many more private contracts. And I don't think in a world where there's freedom, people will ignore the freedom to contract, because I think it's almost like a First Amendment right. This ability to contract is very much instinctual, the ability to trade. Yes, ma'am?
If people could just rip stuff off kind of without having to like obey a lot of and dance around all these different laws,
Right.
would that actually undercut like more dramatic innovation, because you can just like take stuff and copy it and like not really have to come up with something that's distinctly your own? So wouldn't that actually like slow down?
It might slow down incremental innovation, because people would say, well, we don't, you know, it's like.
But incremental innovation adds up to bigger.
Yeah,
big
this is a
things.
funny story. So I've been a very gadgety guy, but I've been like following the market for these memory sticks and what they can do. I mean, I could tell you stories about this. I've probably seen like every brand of a combination memory stick, small MP3 player, and they're all different. And it's amazing. No one has gotten this right. No one has gotten what buttons do you press, how easy do you press them. No one yet has gotten the user interface. I mean, I've got like 50 different brands of these devices, and I'm sure, I am absolutely certain that I could figure out a better user interface. Now, your point is, well, if I could just recreate the exact copy of this, why do I care? Why am I incentivized? But I think still, I would still be incentivized to get it right, particularly if I'm putting my name on it, and particularly if I want public recognition. Now, to your point, I think lots of overseas manufacturers think that exact way, which is, we don't need to do any incremental invention. This is all about cost cutting. We've got to get this device down to under $5, and then huge volumes can be sold. Like DVD players now, I think, are down. I've seen them on the market for like under $39. That would have been unheard of a few years ago. That, you know, a literal piece of electronic equipment for your home, plugging into your TV and working, is under $39, because they've got the cost function down. They've been able to duplicate it with very little royalties. So I think that goes both ways. I think it depends on who you talk to, and I think it also depends on what I'm calling this cultural instinct to reach this flow state. I think in some cultures, it's very much desired and wanted, and people want it for themselves, and maybe in others it's not. Yes, sir?
Despite the desire to innovate, in some industries, specifically like small pharmaceuticals, wouldn't it become economically impossible for innovation? Because there's so much money involved in creating that initial drug that you can't, and very simple to copy, especially in small molecules. And a copycat drug doesn't have to go through FDA trials, and if you don't have an FDA, any sort of process to prove that it's safe.
Right.
But for everyone who's doing the generics, spend a lot less money for the exact same product.
Right.
Where does the money come from to innovate the new drug?
I think that's the argument that drug companies have made. What I don't know yet is true, and you may be right. If you stripped all these laws like Thailand just did it, are they going to completely get out of the market in Thailand, or are they going to figure out some other way to say our drug is a higher quality, or our drug has, more safety to it, or what? I don't know. I mean, it's the experiment that I'm wondering. What's currently not present in the U.S. regime is the laws are so interwoven. We can't even have a particular state like Florida or New York experiment with this to see what happens. It's almost like we're locked into a regime and we probably cannot unlock it. It's too gridlocked together for all the reasons you're given, which is people saying, wait a minute, I've got to invest $100 million of research and development to find a drug. And I'm not going to do that if someone can just copy it and copy it quickly. Yes, sir, in the back.
Is it not your gut feeling, though, that, Thailand's a pretty small example, but if the U.S. were to do it, or the, you know, if you had the U.S. and Europe do it, like large scale, you know, all these regulations were dropped. I mean, is it not your gut feeling? Because it certainly is mine that things would, like, you know, drug innovation that takes $100 million.
Disintegrate overnight?
Yeah, it's just not gonna happen. Maybe not disintegrate overnight, but I mean, like, fall apart because, yeah, these companies that are putting huge, any industry that has huge development costs seems like would be totally screwed.
Unless you could imagine a world in which people start to buy based on quality. Where you imagine a world where people say, and I know there are some people that go into a Safeway and they won't buy generics. They just won't. They just base it on quality. They say there's a brand there, there's a large company there, I feel more comfortable. Yes, sir.
I guess the thing I'm kind of thinking on the same thing is, if you drop these things, you're still going to have innovation, because I do agree with you that people are not inventing and innovating and writing things kind of because they think, oh, down the road I'm going to make a lot of money.
Right.
But once they kind of come up with that innovation, like an author who writes a book, he still needs a company, more or less, to put the book together, to market it.
Right.
And that company, why would they do that?
You're making a point that I am hinting at when I say, is it a threat to creativity or is it a threat to innovation? I'm distinguishing the two, and you are as well, because the truth is 80% of what gets to the market is kind of done by either the sole inventor or a small group of researchers, not this gigantic company. And it's kind of the last 20%. I mean, I'll tell a short story about this. I had the great experience of watching not only Apple Computer grow, but I don't know if any of you remember, because it's now decades ago, the original spreadsheet was called VisiCalc.
Amen.
Right? So now, the story of VisiCalc is two guys, Bricklin and Frankston, in Cambridge, come up with this great invention where they say, you can put numbers in a cell and all the cells change. So initially, all the real estate brokers were really happy. I mean, I watched this, it was in real time. I was one of the lawyers who said we should get a patent on that. We didn't represent Software Arts. Bricklin and Frankston had this little company called Software Arts, but it was just the two of them that were the inventors. That created something magical, because people saw personal computers completely differently when you could put some numbers in a spreadsheet and watch the, you know, all the action happen. And it generated excitement. Well, Filestra, Dan Filestra, who's still in the software business, was the marketing guy. And he said, well, I'll do a deal with you, and I'll market your software. He was on the West Coast, they were on the East Coast. We represented his company, originally called Personal Software, PSI. Eventually changed the company to VisiCorp. VisiCorp sold VisiCalc. Neither one of them filed a patent in disregard of legal advice on the visible calculator, VisiCalc. And what happened is Lotus 123 came in and sucked the life out of them, and then Microsoft Excel sucked the life out of Lotus 123. And it was like no one had any patents, because it was a period of time when lots of software inventors weren't really sure they wanted to put their money into patent prosecution, because the law was uncertain about whether or not patents would issue on software. But really smart entrepreneurs did it. And what developed over time are these huge organizations around both VisiCorp and Software Arts got very big, thinking that they had this great franchise in VisiCalc, but they had no patent protection. So your point, which is, well, maybe it works for, and my point too, maybe it works for the original creative instinct to get the product to prototype, but when you actually have to build a company that provides, you know, product support, installation, telephone support, warranty, manuals. I mean, you open up, I had the privilege of opening up an HP printer last night. It's amazing how much paperwork you have to get through to kind of get to actually plug the thing in to make it work. And, you know, step 18, and it says if you do step 17 before 18, you make room in your computer. And, you know, whoever you're with is pointing to, you're doing step 18 before you do step 17, you're driving me nuts, you're going to ruin my computer. And you're saying, I thought you could just plug this stuff in and it worked. But you're right. And I think oftentimes the creativity happens, but the innovation can't happen without actually having something that will draw the venture capitalist to it. What I keep wondering is, what could you get rid of that would open up things, or what could you change? And maybe that goes to this next slide, which is, what's best? not what if, but what's best. There's a professor here, Sam Savage, who teaches risk analysis, and he wrote a program that kind of does optimization. And he says, well, you shouldn't really ask what if, you should ask what's best, and then look at what the optimized approach would be. I don't see any lawyers talking about, other than Larry Lessig, if he's still licensed practice law, just saying get rid of everything, saying something like, well, how do we optimize what we have? So here's my recommendations, and I know there were some other questions, but let me tell you what my recommendations are on what's best. Number one, shorter patents. Maybe much shorter patents. Now maybe the drug case deserves a longer patent, but I can tell you it doesn't make sense to me that a software invention has a 20-year patent when most of the software is going to be obsolete in like 5 or 6 and probably should be in the public domain. But maybe a drug patent gets longer. Right now the patent system is uniform across everything. Incremental invention, major pioneering invention, it's all the same. It all goes right out to 20 years, maximum 20 years. Shorter copyrights. Maybe 10 years, not 100 years. There seems to be something that's just way out there, and I'll tell you what happens as a result of this. There's more pressure on the fair use doctrine. When you have these long copyrights, when people start to use other people's copyrighted material, you see a lot more defenses based on, well, I think I'm doing a fair use. I don't think I'm infringing. So it's sort of like other defenses come into play. Limited trade secrets. Maybe there needs to be some type of registration process, even an escrow, that says, here's what we're claiming our trade secret is. Maybe that would avoid some uncertainty about what a trade secret is. Limited trademarks. Maybe they should only protect against direct counterfeiting. I know right now Levi Strauss has something like 100 lawsuits pending. It was in the New York Times earlier this week. You know what it's over? Who's wearing Levi's? I'm sure someone. Stand up and show us the back pocket of your Levi's. The back pocket of those Levi's, just stand up.
Actually, they're not.
Oh, you don't have Levi's? You thought you had Levi's on. You have some other brand on. But Levi's have a little red tag on the back pocket, and they have this little sort of like, you know, I don't know if it's a V or an M, but basically a design. Well, there's lots of other companies that want to have a similar back pocket. And Levi's takes anything that's not a straight stitch across the back, if it has any curvature to it, they literally say, you're copying our mark. Our trademark is the stitching on the clothes. And they have like 100 lawsuits going. 100 lawsuits. I mean, it's got to be costing them a fortune. And to some degree, as you spend money on legal, you take away from the budget that might be innovating. You take away from the budget that might be generating more creativity. Now, other IP rights, I mean, really you get to this question of, as I said, gulp, contract rights. Can we imagine taking those away? And there is a thesis that says if you take all this stuff away, people will eventually just turn to private contract rights. Yes? Do you have a question? Were there other questions? Yes, sir.
I had a comment about the pharmaceutical industry that if you were to take away patents altogether, maybe alternative creative financing methods would come in. For instance, you could offer to the public a deal which says that, you know, someday you're going to get old and there's a whole bunch of diseases out there. If you spend some money, help us do some research, then you will have access to these drugs at a much lower cost. And then get access to a wide amount of public finance.
So there would be more of an incentive to promote the licensing of the patent on a basis that might be sort of more like, in a sense, open source of, we're going to open this up, we'll do a deal. In fact, that's the story in the Wall Street Journal, that the drug companies are scratching their head and saying, well, maybe we like really kind of force the issue on the Thai people. Like maybe we should have been listening to the government when they were saying, look, we have to have these drugs and we're willing to do a deal with you, but your price is too high. So in a way you could say there's an interesting negotiation going on, which is the drug company said, get lost, we're not going to reduce our price to that, and the Thai government said, well, watch us, boom, now will you negotiate? You know, it's almost like this point about contract rights are being played out in Thailand. Because to some degree, I have to believe that the Thai government's saying to themselves, gee, you know, if we do this, there might be a backlash somewhere. You know, the U.S. Trade Department, maybe, you know, some treaties are being violated here. Maybe we're not going to be able to get a supply agreement that we want. Maybe there's some drugs we want that, you know, we can never get as a result of this. Maybe, you know, we're aiding the AIDS population in Thailand, but we're like ruining the diabetics who are now not able to get drugs. You know, there's sort of a push and pull that's going on here, and you don't have to be that sophisticated to figure out that there's going to be some arm wrestle. Something's going to happen. So it's interesting to think. So I want to end with the remark that was made, over 100 years ago. I think it's on this slide. Is a way to think about this is we have to start thinking about optimizing the batch of intellectual property rights. So I don't join Larry Lessig's camp of saying, let's sort of like get rid of everything and talk about everything being in the public domain, because I agree with most of the sentiment in this room that there is something more that's needed for innovation. I think the creativity will still happen. I'm just not sure the innovation happens, the delivery to the market happens. I think there'll be a lot of talk, but not necessarily a lot of that final 20%. So really in the words of Lincoln, and this is what he said back in 1850, discourage litigation. This is what in his speech, that persuade your neighbors to compromise whenever you can. Point out to them how the nominal winner is often the real loser in fees, expenses, and wasted time. And I think that's the thesis that we have to imagine on a go-forward basis, where in the future, there's a lot less litigation and there's a lot more licensing, kind of your theme, a lot more open the intellectual property rights that do exist that aren't necessarily so much out there to clobber. And I'll tell you, I think that the courts are moving in this direction. This whole pushback from the patent troll companies, these companies that are acquiring lots of patents, like a hedge fund of patents, and then bringing lawsuits. The way the courts are pushing back on that, and it's really almost in the words of Lincoln, they're saying, well, you can file your lawsuit, and you can win your lawsuit. But when it comes time for me as the judge to sign off on the judgment, the only remedy that I'm going to give you is what a reasonable royalty is anyway. So you might want to think about negotiating a reasonable royalty to begin with, because I'm not going to give you an injunction. I'm just not going to do that.
It's like the BlackBerry case.
Yeah, the BlackBerry case, in a way, was sort of a precursor to the Federal Circuit, which is now the highest reviewing court, except when the Supreme Court occasionally takes a case. The Federal Circuit is saying, in cases that involve companies that don't actually have products, where there are lost profits on a particular product, where they're just licensing paper patents, we're going to force them to simply negotiate royalty deals, because if they don't, we're going to do it. We're going to impose a royalty. So it really puts everything back in the direction of maybe parties have to sit down at the front end and negotiate based on what they have. Not based on a view, well, I can get a better result through an injunction in court. So I'll take other questions that people have, or comments, or, yes, sir?
Just a question, going back to what that philosophy guy, or the guy with the long name?
Oh, Csikszentmihalyi?
Yeah.
Mihaly Csikszentmihalyi, yes.
Under our current patent laws, there is kind of like a built-in economic incentive already.
Yes.
And that makes it possible for people to have jobs, where their job is to be creative and innovative.
Yes.
So under his idea, wouldn't that mean that not only would you have 150,000 bits of
right.
free time innovating,
yeah.
you could actually have an additional 150,000 bits of work time innovating.
This is called psychic benefit that people, oftentimes the advice to people who are graduating from school is, do what you love and the money will follow. And the attitude is, the psychic benefit you get from a job that you really love, you get to work in the morning, or you roll out of bed and go to your computer, whatever it is that constitutes the start of the activity, is so psychically rewarding that's putting you into that state of flow or something near it, that you can't think of doing anything else. You're not thinking about, well, what's my bonus going to be? You're just thinking, I love what I do.
But I guess the point I'm getting at is if you get rid of some of these guaranteed economic incentives,
yes.
then maybe that
the job goes away?
Yeah, you might be losing that super genius now has to work at McDonald's just to make ends meet and can't spend his time and could have created something amazing.
Let me be clear, just because this is on tape. Mihaly Csikszentmihalyi doesn't have a view about intellectual property law. This is my view, sort of transplanting into it what I think his theory leads to. I agree with you that when you start to change sort of the fundamentals of a capitalist economy, you better be very careful Because as you pull at one end, other things happen. You know, you might say, that person's going to move to Canada where there is a better job because there are some patent laws, or is going to move to Europe because it's a worldwide economy and talent does move based on where they feel more appreciated. But the interesting research within the business schools about what actually leads to employee satisfaction, money is not necessarily at the top of the list. Recognition turns out to be a really big factor. And so those companies that use patents more as recognition tools, sort of what's sometimes called the defensive use of patents. They acquire lots of patents, they never sue on them, they just use them to say, hey, if you sue us, we've got like this arsenal of patents, you may want to think twice. Or they do these cross-licensing deals. Those companies use patents as reward systems. They say to people, oh, by the way, when you innovate and you're in that creative state, you know, write it up. You know, don't just jot a few notes, but make a disclosure that we can file, because we want to reward you. We want to acknowledge you, and they get these beautiful plaques for people, they have their name on it. And it turns out, that turns out to be a really important factor, because lots of inventors, lots of people who do a lot of creativity feel really good when they're recognized. In fact, that's a thesis, I think, that you hear within the free camp or the public domain camp, that you get rid of all the IPR rights, all the IPR stuff can go out the window, so long as you publicly recognize the inventor, you'll always get more creativity. It's almost like, instead of having a patent system, we'd have some sort of, you know, notable achievement award. And in the newspaper, there would be, you know, some announcement about someone just created, you know, a new standard for video or audio or whatever, and this is his name. The interesting part is you never really find out. Like within Apple, I think there are exceptions. The folks who signed the inside of the Apple computer were specifically allowed to be recognized. But I don't think people know. Do people in this room know who actually invented the iPod? Do you actually know who did the software for it? I'm not even sure the About box includes all the names anymore. I know some companies still do, but maybe not. Any other questions? With that, I think I'm out of time, and we'll appreciate and thank you for letting me come to spend the time here tonight.
Thank you.